Voting rights. Article 1, Section 4 of the Constitution says the times, place, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time, by law, make or alter such regulations, except as to the places of choosing senators. The Fifth Amendment to the United States Constitution said the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The Voting Rights Act of 1965 established nationwide protections for voting rights. Section 2 of the Act is a general provision that prohibits every state and local government from imposing any voting law that results in discrimination against racial or language minorities. Other provisions specifically outlaw literacy tests and similar devices that were historically used to disenfranchise racial minorities. The image you see here is of a literacy test from the state of Louisiana. These are the second and third pages of that literacy test from the state of Louisiana, which was designed to prevent African Americans from voting. This chart shows the impact of the Voting Rights Act of 1965. On the left, you see African American and white voter registration before the Voting Rights Act. On the right, you see black and white voter registration after the act. Notice voter registration increased dramatically for all races, white and black. A core provision of the Voting Rights Act is the Section 5 pre-clearance requirement, which prohibits certain jurisdictions from implementing any change affecting voting without receiving pre-approval from the U.S. Attorney General or the U.S. District Court for D.C. The District Court or the Attorney General has to approve the change to voting laws by deciding that the change does not discriminate against protected minorities. Another provision requires jurisdictions containing significant language minority populations to provide bilingual ballots and other election materials. Section 5 and most other special provisions apply to jurisdictions encompassed by a coverage formula prescribed in Section 4B. The coverage formula was originally designed to encompass jurisdictions that engaged in egregious voting discrimination in 1965, and Congress updated the formula in 1970 and 1975. As enacted in 1965, the first element in the formula was whether on November 1, 1964, the state or political subdivision of the state maintained a test or device, like a literacy test, restricting the opportunity to register and to vote. The Act's definition of a test or device included such requirements as the applicant being able to pass a literacy test, establish that he or she had good moral character, or have another registered voter vouch for his or her qualifications. The second element of the formula would be satisfied if the director of the census determined that less than 50% of persons of voting age were registered to vote on November 1, 1964, or that less than 50% of persons of voting age voted in the presidential election of November 1964. This resulted in the following states becoming in their entirety covered jurisdictions: Alabama, Alaska, Georgia, Louisiana, Mississippi, South Carolina, and Virginia. In addition, certain political subdivisions, usually counties, in 4 other states, Arizona, Hawaii, Idaho, and North Carolina, were also covered. In 1970, Congress added a second prong to the coverage formula, identical to the original formula except that it referenced November 1968 as the relevant date for the maintenance of a test or device and the levels of voter registration and electoral participation. This addition to the formula resulted in the partial coverage of 10 states, including Alaska, Arizona, California, Connecticut, Idaho, Maine, Massachusetts, New Hampshire, New York, and Wyoming. Half of these states, Connecticut, Idaho, Maine, Massachusetts, and Wyoming, filed successful bailout lawsuits, meaning they were withdrawn from the coverage. In 1975, the Act's special provisions were broadened to address voting discrimination against members of language minority groups, which were defined as persons who are American Indian, Asian American, Alaska Natives, or of Spanish heritage. As before, Congress expanded the coverage formula based on the presence of tests or devices and levels of voter registration and participation as of November 1972. In addition, the 1965 definition of test or device was expanded to include the practice of providing any election information, including ballots, only in English, in states or political subdivisions where members of a single language minority constituted more than 5% of the citizens of voting age. This third prong of the coverage formula had the effect of covering Alaska, Arizona, and Texas in their entirety, and parts of California, Florida, Michigan, New York, North Carolina, and South Dakota. In Shelby County versus Holder, a 2013 Supreme Court case, the court struck down the coverage formula, saying it was unconstitutional, reasoning that it was no longer responsive to current conditions. The court did not strike down Section 5, but without a coverage formula, Section 5 was no longer enforceable. Should states have strict voter identification laws? As of August 2022, 35 states enforced or were scheduled to begin enforcing voter identification requirements. A total of 21 states required voters to present photo identification at the polls. The other 14 accepted other forms of identification. Valid forms of identification differ by state. Commonly accepted forms of ID include driver's licenses, state-issued identification cards, and military identification cards. In 2011, Texas enacted Senate Bill 14, which required that every voter must present one of the following at his or her polling place: a Texas driver's license, a Texas election identification certificate, a Texas personal identification card, a Texas concealed handgun license, a United States military identification card containing the person's photograph, a United States citizenship certificate containing the person's photograph, or a United States passport. At the time, Section 5 of the Voting Rights Act still was in force, and it required that the Texas voter identification law receive pre-clearance by the United States Department of Justice before taking effect. The DOJ denied pre-clearance on March 13, 2012, and this initiated a series of lawsuits and court battles that lasted several years. On August 30, 2012, a three-judge panel in the United States District Court for the District of Columbia unanimously struck down Texas's voter ID law. The court ruled that the law would negatively impact minority voter turnout and impose strict burdens upon the poor. The state contested the ruling. On June 1, 2017, Governor Abbott signed Senate Bill 5 into law, amending the state's voter identification requirements. For voters lacking photo ID, the law established an affidavit option requiring voters to sign a form stating that they were unable to obtain photo identification for one of the following reasons: lack of transportation, lack of a birth certificate or other documents needed to obtain identification, work schedule, lost or stolen identification, family responsibilities, or that the required identification had been applied for but not received. On August 23, 2017, Federal Judge Nelva Gonzalez-Ramos issued an order barring implementation of Senate Bill 5, finding that the revised legislation was not an adequate remedy for the findings of discriminatory purpose and discriminatory effect in Senate Bill 14. On April 27, 2018, a three-judge panel of the United States Court of Appeals for the Fifth Circuit issued a 2-to-1 ruling reversing the earlier district court order that had barred the state from enforcing the provisions of its voter ID law. And then on June 19, 2018, the Fifth Circuit dismissed a further appeal allowing Texas's voter ID law to stand. And that's where we are today. The voter ID law is in place with the affidavit system that was created by Senate Bill 5 about 5 years ago in 2017.